think it's been extremely missing from our communities as far as teaching and having these conversations around wills, trust, and issues and things beyond. From even when you think about elderly care, when you think about power of attorney, medical power of attorneys, when you think about really how to prepare for those. How many of y'all in here are taking care of elderly parents or taking care of? Oh wow, wow, this is good. This is good. Matter of fact, before I get started, I want to do something. I just want to go around and just real fast and introduce yourself and say what you hope to gain after these 8 weeks. It's gonna be a quick 8 weeks. So just introduce yourself real quick.
Well, hi everyone, my name is Lauren. I've lost my parents, but we did have cousin staff, and I just want to make sure what we did have.
All right, so by the time you watch this, I will be.
I want to hope to build generational wealth. And so, in keeping and hoping to build generational wealth, God finds these strategies that will help me do that. Good evening, my name is Nancy Smith-Purdy, and hoping to this understanding build and trust, having successfully married and having a family. I want to say that we have to get my assets, we have to get our assets with family, we're building for everything else and everything. I'm here to try to make it to the conclusion of which is God, the real or trust. Good evening, everyone. My name is Ellen Bell, and I'm here for that exactly also to look down and to get that myself up and doing that. You know, I'm going to say that, and I will, there's been one time we was, and that's what got myself up to the next couple of years.
But I can't hear him. Which one is it?
That I want to make sure that I set up for my young daughter and also help my elderly parents because they really, like I said, coming from nothing and then you build into something. It's not as easy as like, okay, they're gone, but now we have a lot of legal matters that come afterwards.
That's good. And I'm Philip Bell. I just don't know, so I'm here to soak in anything.
Good evening, Candace Williams. Same like everybody else, just kind of gain knowledge in all of that is available to us. We don't talk about this enough in general, and then also share with my parents. I know I've tried to talk with my parents in the past about wills, trusts, and certain documents. And one parent is old school and one's like, I don't want to talk about that right now. And then the other parent is like, you need to go buy documents, but I don't even know where to start. So hopefully knowing where to start with all of that.
Good.
Good evening, my name is Yvette Ragland, and I do want to learn more about wills, trust, and beyond, power of attorneys, living wills, and you just hear so many different things, and I just don't know which way to go. I only have one child, I have no grandchildren, so I just want to make sure that everything is set for her. Okay?
My name is Kiana Rainey. My husband and I are here to learn a little more, to learn how to pass that knowledge down to our children and keep the knowledge and everything going.
Good evening, I'm Tamara Ennis, and I'm here to hear more about wills from my family.
Russell Young with Boyd Helena. And the same, wanted to say about more wills, trust, and information on that.
Monique Wood, we had a line about wills, trust, power of attorney, have elderly parents that stay with me, and I have adult children. So I want to make sure that my parents are set up for where they need to be. And if, when my demise comes, because it will happen, that my adult children are set up for where they need to be and what they need to have.
My name is Faison Bay. I'm just here to learn something new.
Good day, good evening. I'm glad that I'm just here to absorb as much information so that my kids will be great.
This is great. Give yourselves a round of applause because it takes a lot of courage to have these type of conversations. We heard that in most communities they don't even have this conversation. It's very taboo. Like you don't want to talk about what's inevitable. We all gonna hit that big old box one day, and we're all going out one way. So how to prepare? It's not to go out because you're afraid, but it just takes courage that people avoid this conversation until it's too late, until they're not in their right mindset, and you can't find documents. And so oftentimes family lose the biggest asset they have, which is their house, which has a lot of wealth and it gets caught up in, I don't want to get into Phoenix's thunder, but it gets caught up and the state begins to get custody of a lot of things. You end up paying a lot of penalties and taxes and stuff like that. And so it's important that as we build out what we call here Destination Duffy's 2034. Part of it is economic mobility. We want our community to be financially stable. We want our community to be able to have the resources and the tools that as Dumfries grows, that they're growing too. We don't want to gentrify a community, but we want to create some regeneration, and we want to make sure that the community is also growing with the development that's happening around town. And so it's all about how do we have these conversations as well. As I was preparing for this, I saw a statistic that said nearly 70%, it might be more than that, 70% of Americans, even more, they said in the Black and brown communities, don't have a will. That means that the state, not the families, when the person passes away, they decide what happens to everything that they work for that they thought was going to go to their family. So when you think about it, it's not about money alone. It's about dignity. It's about peace. And it's about the legacy. Not the legacy you leave for people, but the legacy you leave in people because of what you left there. And so this isn't just about building businesses and parts for us. You think about town government, that's what we're about. But this is about building stronger families and securing our families, and so building a legacy. So if you don't plan, you actually lose, right? Because if you fail to plan, you plan to what? Absolutely. Your family, they lose time. Your families lose money. They lose peace of mind. And so we're asking that you commit the next 8 weeks to go through this series with us. And we even are going to give you a carrot, right?
I don't know if
to help you pay for your will, to pay for if you need a digital tool. We're going to, you commit 8 weeks with us, we're going to give you $50 towards your thing. I'm going to give you the extra $50 show us. All right, I like that. And so, it's going to go towards your will, and so we don't want you to miss the chance. Overview of the program. Today, you're going to get introductions to wills, trust, and beyond by Phoenix Ayotte, right? Did I say that right? She's going to come in, and she is one of the best estate planning firms in this Northern Virginia region. She's been doing tremendous work. Got into this business, she'll tell you a little bit because of what she saw this type of thing does to families. And so her specialty and her niche is estate planning and getting people outside of this type of position. So you'll hear from her today. Next week, you'll learn how, once we get these documents, how you can store it, how people can be able to get access to it. And we'll look at some digital boxes, so, and who email, all that other stuff. So we'll get into some digital access. We'll come back the next 3 and 4 weeks. We're really going to get in. It's going to be a hands-on type of thing where you're really going to go through doing your wills. So we have some will clinics and we have some real legal centers. You'll learn about trust as well. Weeks 5 and 6, we'll get into a lot of the insurance and the family protection. Week 7, we're going to organize, preparing power attorneys and stuff. And then week 8, we'll actually be doing one of our council meetings. You'll actually get a graduation, certificate of completion, and your value towards it. And so we're asking for you to, if you can't attend 8, we're asking to receive the cash. We want to see you do at least 5 plus more sessions. Is that fair? Is that all right? Can we all agree to that? So you can make this week will be in person, and the next 6 weeks we'll do virtual. So you all, I see y'all got happy about that. Clap for virtual, right? So if you make sure Ray in the back and the team, when you register, came in, they got your email addresses. You will get a email link for, what is it, Ray, Teams, for them to join us virtually for those 6 weeks. So you'll be able to join us from the comfort of your home for those type of classes. So that's how it works. So the sessions will be every Wednesday starting at 6:30, right? So we'll keep the same day, and we'll have all the resources to be able to provide for you. Now, any questions before we bring in our first committee questions? Anybody, concerns? I'm glad that you all got to share what was important to you. And if that's the case, the reason why I thought this was important too is because as we begin not only look at the statistics, but I looked around, my family. I remember when my grandfather passed away, he had this big old house in Norfolk, right, in one of the big neighborhoods. This man had 6 bedrooms upstairs, 2 beautiful bathrooms. I mean, this house was huge. And then, the family kind of feuded. There was no wills or instruction. Another brother owned a piece of the house or had his name on it. But eventually, now you drive down there, the city took the house because of taxes. The house is torn down. And so you had this big old house. And we began to talk about, as you look at what you can do with trust, how many ever heard the term trust fund baby? Right. And a trust fund baby might not be you, but a trust fund baby can come from you. and it's going to be you learning, like, what a trust is, how you can protect it, how you can actually give direction that will remain even when you're gone. Anybody ever seen the series Power, right? And then you had this kid named Tyreek, right? And Tyreek's daddy is dead, but Tyreek is still mad at his dad because his dad told him he can't get no money until he go to college and graduate college. That's the power of trust. Like, you can tell your family members what to do when you're not even here. And so your instructions are being that trust. One of the biggest trusts that's been out there, anybody heard of Benjamin Franklin? The Big Franklin Trust has split 2 or 3 times, but every 100 years, this trust is just making money and it's splitting. And so you got these type of living trusts that's been going on for years. And it's a world that we haven't been exposed to, and you begin to start to learn and then how to set it up. And especially, when we do this series, I want you to definitely learn how to use insurance as a financial tool to create wealth, right? And so families, everybody in the family put insurance on it, and it's tied to the trust. And the trust gets paid out through insurance, not the family members. That way, all the family agrees with the trust and how they put it in, or how the money gets paid out, and how people get access. And so we'll have those type of tools. But I'm excited to bring on our first guest speaker in this series. And if you got any questions during this is very interactive. We're actually recording and live streaming, so if you're not capturing all the information or don't get all the notes, you'll be able to go back to our YouTube channel and be able to pick up and watch this, because we are very serious about you getting the information. So from the Department of Estate Planning in Northern Virginia, please help me welcome Ms. Phoenix Ayotte, please.
Do I have to hold it? Does this work? Okay. Which one? Okay. I appreciate that. So I'm an informal
Voting
panel. So anybody who's brave enough to answer when I start calling on people, we can get it started, but I'll probably prepare people as we go along. Okay. So I'm Phoenix Ayotte. I have my own law firm in Arlington, Virginia. I've been a member of the bar since 2008. I'm going to tell you a little bit about myself so you understand. Before that, can I check? Do I have until 8 or 8:30? Okay, just want to make sure. Anything else that's on the program? So what my mission in life is to make 3
world a better place and to help people. So when I graduated law school, what I chose to do was to be a public defender, and I had hundreds and hundreds of cases, probably thousands, and did that for a long time and always wanted to continue doing that. I was fortunate enough to be in one of the best offices in the Commonwealth, which is the Alexandria office. But eventually I had children and I got burned out on that. My mother got ill. She was diagnosed with early onset Alzheimer's. That was about an 8 to 9 year journey. And so the reason of estate planning is what I do now and what I feel is really my calling to help people this way is because the best thing, I was telling Derrick, the best thing that we did, the Alzheimer's Association says, as soon as she got her diagnosis, very young, 54, they said, go to the lawyer, get your affairs in order. I can't tell you, over the years, being a caretaker for someone, all of the administrative and bureaucratic challenges that there are. Just doing simple things like getting forms signed or getting something from disability insurance or the Social Security Administration, not to mention the everyday, day-to-day stuff of getting care helpers and things like that. So that was such a blessing for our family. And we were really, really fortunate that we got that piece of advice. And I consider it my mission to get out there and be sharing this information, at least prompting people to think about it if you can, before it's too late. The other big area of interest of mine, and I'm writing a paper on this now, is the intersection of legal capacity and medical capacity. A lot of lawyers won't touch, helping you execute documents if they think that someone may not have legal capacity, but they don't really understand now that we have so many more people with medical issues, neurological issues later in life, or different disabilities, that you can still have legal capacity, sometimes just at certain times of the day. But we don't want to commit malpractice. We don't want, there to be a big court fight later. So it's hot potato for a lot of lawyers. And I want to empower more lawyers to be able to assist families with that. But if you know anyone who's having an issue like that, within the bounds of legality, you can send them to me and I'll make sure that we're helping them. So thank you for going around the room and introducing yourself and what you care about. I took some notes. I wasn't quite sure what we would need to go over today, so my presentation is very general. We're going to go over, what is a will, the probate process, what is a trust, kind of educate you what the differences are, and I'll tell you why they matter. But I really think that it's the most helpful if you just ask a lot of questions. Okay. Let me figure out how this works. No. Okay. So since we're trying to get to know each other, let me ask y'all, who in here has a We'll just talk really loud. So who in here already has a will? Raise your hand. One person. Okay. Who in here has an advanced medical directive? Yes. Remind me your name? Ada. Okay. When and why did you get an advanced medical directive? Mm-hmm. I said, and it's not very extensive, it's literally until she's a minor, I want extenuating circumstances, yes, do everything to save my life. Mm-hmm. But because she is still a minor, you do whatever you can to keep me alive. But also, after 30 days, if there's no sign of life, I'm taking off that. Mm-hmm. Just because she is still a minor. And you don't have to say the name or anything, but the person who's going to come in and be there to communicate your wishes and your decisions, is that a family member, a close friend? It's a close friend, so not a family member. Did you have a conversation with that person about it? Yes. Is anyone else thinking in those terms at all? Has ever had a conversation about it? You have? Yeah. You want to tell us anything about that?
Just how would they, if something would happen to me, you have to be alive, just to make sure that my husband knows the state that I would want to be in. Like if something catastrophic were to happen to me, please don't leave me alive. Let me go. Mm-hmm. And here's the direction, and I would want him to carry that out, and I would also tell another friend because people's emotions get high and they want to hang on for hope and stuff like that. Let me go. Mm-hmm. That's not the quality of life that I would want if there's no coming back to who I am. So I wanted to make sure that he knows that, but I also need to like put it in writing so that if that does happen, and he's incapacitated too, if somebody knows what to do.
Absolutely. And this is something we'll get into more of the advanced medical directive, but I think that's really, you can't put a will in place without doing your advanced medical directive at the same time because they tend to go together, okay? And all of this, the will or the trust, the powers of attorney, the advanced medical directive, you know, all the other documents that go into my estate planning packages, they're geared towards leaving behind your family a gift. Okay, just imagine, has anyone here been through grief or lost a loved one before? Okay, it's stressful. People are, you know, you already still have your obligations and all the administrative and personal things that you have to do, and now you've got this on top of it. The easier it is for you to make decisions and just kind of go through the motions because you have a guide. You're so grateful for it. Families are so grateful for that. So it is a gift to your family to do this if you can, if you have the ability to do it. So we're going to go over that. Estate planning is important because you guys already gave some of the reasons, but you're protecting your assets. So there's an entire conversation we have that's just about asset protection, and I heard maybe 5 of you at least. I stopped counting after that. Talk about that you want to make sure that you're leaving a legacy, that things are set up. That's asset protection, okay? That's, are we making sure that the city's not taking the house, or that the taxes are paid, or you know, are we maximizing everything? Are we going to lose value? One of the conversations is don't ever put your kids on your deed while you're still living. A lot of people don't know that. If you do that, they're losing the step up in business for capital gains. I can go into that more later, but there's a bunch of things that go into this. If you have an investment property, do you have it in an LLC? Do you have your umbrella insurance? So that's really, really important to go through. Guardians, if you have minor children, right? And I do. And then secrecy or privacy, it's better to have said that. You know, when you go through the probate process, has anyone here been through probate after they lost a loved one and had to go to the court? You have? Tell us about that. You didn't need to go through probate? Okay. But you did go through probate. I think you always lose money when you're going through probate. Sometimes it cannot be avoided, and sometimes it's the correct thing to do. It really just depends on your asset profile and what you have to establish and what outcomes you're trying to achieve. But how long did it take? 2 years. Mm-hmm. And was it?
That's all. I got no clue for that catching.
Did everybody hear that question? Okay, that's a really good question. So no, the will would not take precedence. Your spouse has a legal right to inherit. They would have to disclaim their interest through a prenuptial or postnuptial agreement, or you can just execute a new will along with a disclaimer of their spousal share. Okay. However, in the instance where if you have a child and then you marry later, both your child and your spouse have a right to inherit. They both have a right to inherit. So your child from a prior relationship, yours or your spouse's, is still going to benefit from your estate. Ada. Oh, prenups get around all of this. Yeah. Prenups get around all that. Just make sure you use a good lawyer who does. So for the thing for prenups, if people don't know, is that if there are not full disclosures of the assets on both sides, it invalidates the prenup. So you can't do these. I love LegalZoom, right? I love the fact that it exists. I'm a free market person. But if you just do a form and you say, hey, let's sign this because we agree on stuff, you haven't gone through the disclosure process. It's good to just have a consultation with someone and make sure you're at least checking all the boxes, even if you're not going to pay the lawyer their whole fee. Okay. Prenups, postnups, or we call them, marital asset agreements, those all apply. Okay. So who wants to hear how probate works?
Before you start talking about
Yes.
probate, just one question. Christy. The children that you're speaking of, are they minors, or are you talking about 18-year-olds and above when you discuss this?
When we're if they have even if you have a spouse, any child, any life and being that's yours. Yeah. There are specific laws that determine whether or not a child or a person has the right to inherit as a child. And because we're in 2025, we've got embryos, we've got different types of donations, we have adopted individuals, we have people who were not recognized as children or didn't have a familial relationship, and those are all a bunch of different tangles that can come up. But just as a basic matter of right, if you qualify as, under the law, and you can litigate it, then you have a right. Doesn't matter if you're a minor or not, because your guardian, whoever is your guardian, stands in your shoes to assert your right. Yeah. Anybody else have a question about that? Okay. So probate. I'm gonna stand here. Okay, I'll keep on this. So probate. Here's how it goes. You have the will. You bring the will down. You get a death certificate. So the first two things you do when someone passes away is you order the death certificate, and then you go change the locks to the house. Okay. Why do we change the locks to the house? So no one can get inside and take the stuff. It happens more often than you think. Sometimes it is not for a nefarious reason. No one has ill intent. They say, Grandma Jones always told me that I could have that lace tablecloth, and I have an event and I need that lace tablecloth, so I'm just going to go over there and get it because everybody's busy. Different things happen. Like you understand, maybe you're trying to streamline the process for people, but change the locks. Make sure you're the person who's authorized to change the locks. Don't just go be changing locks. And then you're going to take that will and you're going to take the death certificate down to the courthouse and you're going to file it. Then you have to start doing some other things called filing the list of heirs and saying, here are the people that I find can legally inherit from my loved one's estate. And here's the asset inventory. And you have to do an asset inventory. Okay, so that's what's the value of all their stuff? Where are their bank accounts? Where are their retirement accounts? Did they have life insurance policies, et cetera, et cetera? It would be so helpful if someone had left a list for you, don't you think? Yeah, because that's hard and we're all working. But you have to do that. And then after you've done that, according to the rules, you're going to go and you're going to set an appointment with someone called the Commissioner of Accounts. This is not the person who is going to give you the power of sale or who is going to allow you to distribute the assets. This is a person who is checking your work, and you have to pay them a fee out of the estate. So then you go and you're nodding because you did it before, right? Yeah. And you can have, but depending on what the issues are in the estate, you can have multiple appointments and appearances before that Commissioner of Accounts. Okay, but they're going to check your work, and then you get to graduate to the next level. And if you graduate to the next level, that's when you get to go before the judge and you say, Judge, here's the will, and here's all the stuff that I've filed. We know what all the debts of the estate are. We know who the heirs are, or at least we've published it. No creditors have responded. These are the assets, and it says it should all be split between these three individuals. So now I would like to begin writing checks. Is that okay? And the judge says yes. Or if you have to sell the house before the title company will allow you to sell the house and close the transaction, you may have to have a court order that says this executor is allowed to sign to sell this house, which can tangle up someone's ability to liquidate an asset if it's needed, right? So that's something to think about as well. It can take a really long time. 2 years is not something that I don't hear often. Miss, I forget your name. Would you remind me? Okay, Jennifer, was there one thing that you could point to that caused your probate process to take 2 years?
Not understanding the process. So it went longer than expected. And then when I really started asking questions, they told me that I could have closed it a lot earlier. Yes. So I was paying extra fees for no reason.
Yeah. So small estates don't have to go all the way up. They don't have to graduate from the Commissioner of Accounts. You can just file something, or if the only thing that someone's leaving behind is real estate, then you can file what's called a real estate affidavit in some cases, okay? But having someone think through this in advance instead of you having to figure it out is very, very helpful. Any questions about anything I said before I go on? Yes?
I have a question.
Oh gosh, hold on. We want this to make sure that this is recorded.
Okay, so I was listed in a will as a recipient or a beneficiary for my godmother. When she passed, she was actually really wealthy. She had properties and all this stuff in Old Town, Virginia, in Old Town, Alexandria. She had about 3 wills. She died of Alzheimer's, and, they did a will maybe 5 years before she died, but she had previous ones in the 90s and early 2000s, and her nephew challenged all of it. So I don't know if I never got paid from it, but there were 3 wills that were filed with the court. There were 3 wills that were notified, and it went to the court system. And I don't know the outcome. Obviously, I didn't receive anything from it, but I don't know if anybody else ever did, because it just got tied up in that process of them trying to determine which one was actually the right one to use. So what do you do in a situation like that where someone has multiple wills? I mean, they basically all said the same thing, but you could tell there was a very clear, different track that it was going, leaving all the assets to one person in like the late 2000s when she developed Alzheimer's, and then, started to be cared for by somebody who was taking money from her. And then it clearly changed. So, what does someone do in an instance like that where there are multiple wills?
Such a good question. Did everybody hear? Sorry. It's my electric personality. Okay. So when was that?
This was 20.
Okay. Have you ever gone back and looked at the probate file to find out what the final order said?
I don't even know where to find
What court was it in?
it. It was in Alexandria City.
Oh, that's easy. You just call up the clerk and you say, I want the final order from the probate file. Or you can go down there. The clerks are really nice there. Yeah, sleepy little jurisdiction. But I think that, and I think you should do that based on what you said. Every will, power of attorney, advanced medical directive, trust that you do must revoke all prior wills and codicils. You can update a will. You can change it. You don't have to write a whole new will. You can say instead of Sam, it's going to be Sally, okay, or whatever you want to say. Instead of my gold watch, it's going to be my pearl earrings. You can do that at any time. But every single revision, or what we call a codicil, has to be executed under the same formalities that we require. So in Virginia, in order for a will to be valid or any of these codicils or updates, you have to sign in the presence of 2 uninterested witnesses, people who do not benefit from your will, and the notary. And we all have to be in the same room at the same time. And we have to be able to testify that we don't have to read the whole will. No one has to read all your personal business, but you do have to say, hey, does this have your final wishes in it? Are you here? Do you understand everything that's in there? Are you doing this of your own free will? Or is it Johnny who told you to do this? And so those witnesses have to be able to testify to that. Where you get into problems is when you have not executed it with those formalities, or some of those people aren't around anymore to come. And so that's when we have litigation, right? And and really it's just a case-by-case basis. The court just does the best that they can with the information that they have at the time. There's no predictability in a state law. Yeah. But I'd love to talk more about that if you want to. We had another question over here. Oh, good. Thank you.
My question with all the probate and the taking everything to the attorney and the commissioner of accounts, all that has to be done in the state that that person lived in?
Such a good question. Is that your whole question?
Yes.
Okay. I love that question because that is going to segue us into when we're going to talk later about trusts. If you have property in diverse jurisdictions, then what your executor or personal representative has to do is they have to go through the probate process wherever you are, and then they have to domesticate that in whatever other jurisdiction they're trying to do your property. So it's get through it all the way in Alexandria, okay, and then we're going to take it to Georgia, or then we're going to take it, to Maryland. And I have a transaction right now that is maybe not going to make closing because there was a trust, and the trust is what obviates the need to do any of this, right? So if you have property in diverse jurisdictions, very good idea to have a trust because you don't have to do any of this. And I'm coming to you. Thank you. there was a trust, but for some reason it wasn't funded appropriately. So now they had to go down and just get the stuff done in Florida really quick. And then we have to come up and file it in Arlington before we can close the transaction. So did that answer your question? Okay. And we have another question over here. And I love your questions. Thank you.
What if you have land outside of the country?
The laws of that country are, love that question. I've got some clients with property in El Salvador that I'm trying to finish their estate plan right now. The short answer is that I have to hire a lawyer in the other country to ensure that we have done it right. Sometimes you have to execute a document under the laws of formality in that country. You can still do it here, but it has to be according to and cite their code sections and regulations saying that you want your Virginia documents to be given deference. And you can't say something that's not possible over there. For instance, in France, you cannot write a child out of your will. You can do it here. You can disinherit children if you want. You have to specifically say it so that they're not like, oh, they made a mistake, or maybe you wrote the will, you didn't have the third child yet, and then the third child was later born. That's okay. So if you don't want someone to be a beneficiary of your estate, you have to specifically say it in the United States. You cannot do that in France. Period, the end. So it wouldn't matter. They would never give it deference. Did that answer your question? Okay. Yes.
Are wills, that's a little loud, sorry. Are wills only valid or recognized by the courts if they're filed through the clerk system?
No, good question. It's actually kind of rare to register. Well, do you mean before someone's passed away or afterwards?
Yeah. So like as you're developing the will and putting all the ins and outs in it, and you want it to be like official, does that have to be filed through the clerk system, or would just a notary do, and you can just file it in your own home file cabinet? Like
most people are just keeping it in their places where they're keeping their important documents. Really not a reason to do it otherwise, unless you anticipate that there would be a reason. For instance, clients of mine who are being stationed overseas soon, or they're going on a long trip, is everyone going to be able to find my binder? What if my house burns down? You can file it. And what happens in the Commonwealth of Virginia is that the clerk will accept it, but they keep it under seal. It's not public record. It's just kept somewhere in some archive. Now those are digital archives, so I have a little more confidence in them than if it was just back in the filing cabinet. But yeah. Okay, so that's probate. That's one of the reasons that you want to think about your estate plan, because if you don't want your family to go through probate, even if you have a will, what's the solution? A trust. Who knows what a trust is or has an idea? Okay, I'm going to put you on the spot again.
So you can do a revocable or irrevocable trust, and you can put assets in that trust and directive as to how you want that trust doled out or partitioned out to beneficiaries, and conditions under which you want those things paid out once you've passed, or how you want things handled, essentially.
Exactly. I like to describe a trust as a little safety deposit box, kind of, or safe deposit box. Safe deposit? It's late at night. It's after 4 p.m. So, and it's got, you put all your important things in there, and then on the lid, you put your instructions, and what you're putting in there is your assets. Your money, your life insurance policies, your house, your jewelry, all those things. You're saying, I'm putting these in the name of my trust now. And then on the lid, you've got these instructions that say, and here's what's going to happen to them. And my trustee is in charge of all of that, who should be a trusted person. Because the reason that we have the court overseeing it is to make sure that the executor or personal representative is doing things according to how they should. If you have a trusted person in your life who can do it, you don't need the court to oversee it. You can just have them do it. Okay, that's why you would set up a trust. They're more complicated and expensive, but if you have assets in diverse jurisdictions, if you have minor children, if you're above a certain asset threshold, and I would say if you're starting to have net worth more than $500,000, that's when you're going to want to start thinking about having a trust. If you have a complicated family situation with children from a prior relationship, it's a really good, elegant solution for any of the problems that can come up in those circumstances. Okay, the trustee can only do what you left in the instructions. That's all they can do, but they never have to go and ask anybody for permission to do it. They never have to go to court. They don't have to file anything with the commissioner of accounts. and nobody sees it. When you're going through probate, whatever was in your will, that's public record. All of your assets that they had to do for the asset inventory and file that form with the commissioner, that's public record. When you go and you pull the probate file in Alexandria, you're going to see the list of heirs, the asset profile, and what happened with the case and what your aunt said should happen. All 3 wills, they're there for anybody to look at. I can go pull it tomorrow. So you will avoid that if you have a trust. How do you know if a trust or a will is right for you? My advice is not to go to an attorney or something else and say, I've decided that I'm going to get a trust, or I need a trust, or I've decided that I need a will and a transfer on death deed, because it's such case-by-case basis and it might not apply to you the way that you think. You want to get educated on it, but then you want to ask an expert, here's what I'm trying to achieve. I want to make sure that while my child is a minor, there's a guardian, I'm kept alive, this stuff is held for her so that she can go to college. How do I do that? First, you say what you want, and then we figure out how we're going to paper it up. I know you had a question.
The trust, and like you said, we name a trustee, and just thinking that she's a minor, and there's still several years for her to go. In the trust, can I name her, she is the beneficiary of the trust, but you said the trustee would then execute the trust. Can there be multiple trustees, or like multiple people, as in most likely it would be her father, but I also don't want to give the entire, I guess, authority to him. There should be some other party to make sure that her assets are also being protected.
Anything that you dream up, a lawyer can draft. We are problem solvers. We are solution people. We will find out how to do it within the bounds of legality. That's what we paid to learn. So yes, you can have co-trustees. You can have a trustee who's different than the guardian. You can have a trustee, and then you can have a trust advisor. For instance, I have clients sometimes who say, the person I really trust to make the decisions that I would make is my sister. She's not the most sophisticated person. She's a little scatterbrained, not sure if she's going to be good at the bookkeeping and the accounting and making sure of all that stuff. Well, you can appoint an investment manager of your choosing, or a financial advisor, or someone called a trust advisor, and I would put all these provisions in there so that someone can just kind of hold their hand or make sure that they're, they know every year, hey, did you do this year? Did you do this month? Because you're the trustee. But they are the only person who would have the powers that you gave them. There is really no way it can't be designed. People much smarter than I are doing much more complicated trusts than I do. I can solve probably 75% of the problems that people can solve. When you're working with people who have like super high net worth, and I'm talking people who are like 20 million and above, I don't have that experience yet. That's just never been my people. So, once you get up there, you got to go to a different type of lawyer. But under that, we can do anything.
I'm just kidding.
Your best friend?
No, but that's our children will, right? That's what we want. We want our children to have that much.
I just want to talk to you.
Mr. Wood, would you read this example for us? We're gonna do a little
I read it. I got it.
Oh, you got it? Okay.
You're dying with a will versus without a will. Example, Grandma Johnson was a planner. She owned a modest home in Arlington and had 2 grandchildren she adored. She sat down with a lawyer years ago and drafted a will. In it, she left her home to her daughter Susan, and she instructed that her savings account, about $40,000, be divided equally between her 2 grandchildren, Emma and Jack, to help with college. When she passed, her family went through probate, but because her wishes were clearly spelled out, there was no fighting. Everyone knew exactly what she wanted, and the court honored it.
That is the best case scenario for probate, right? And it is not always required for you to have a complicated estate plan. You want to go with the most simple estate plan that you can for the least amount of money that's going to achieve your goals, okay? All right, now let's talk about dying without a will.
Grandma Johnson wasn't much for paperwork. Grandpa. That's grandpa. Not grandma, grandpa. He remarried later in life after divorcing Susan's mother. When he passed unexpectedly, he left behind a second wife, Linda, and 3 adult children from his first marriage. He had never written a will. Under Virginia's ancestry laws, Linda didn't automatically inherit everything. Instead, she was entitled to only a portion, with the remainder split among his children. The kids who never got along with Linda refused to cooperate. Probate dragged on, lawyers got involved, and what little money there was ended up being spent on legal fees and bitterness instead of the family.
Who wants that to happen? Who has seen that happen to somebody you know? Okay. Linda might be a perfectly nice person, right? But the Susan fans in the family don't really want her to get anything. She's entitled to it though, okay? She's entitled to it, and you wasted a lot of time and money. And so that's unfortunate. Generally, when I'm drafting a will or a trust for someone, I always ask if we want to include a no contest provision. And that provision that I put in there says, you can argue that I'm not doing my job right, or I'm not doing a good job. If I'm the executor, or I'm the trustee, you can always challenge that. But you cannot come in and argue that it's going to be divided between Susan and 3 kids. If you're going to take us all to court to do that, you get nothing, because all you're doing is drawing down all of our assets. So if you're getting a will drafted on LegalZoom or by a lawyer, make sure you're addressing the no contest provision. Did you have a question before that I didn't get to you? Okay. Okay, so we've already kind of talked about this. I just want to re-emphasize that you are avoiding probate if you have a trust. You're keeping your stuff private because it's not filed in the public record. Any of those situations that I talked about, it will help with those ones. Children from a prior marriage, anyone who has special needs in your estate plan, whether that's medical, educational, other types of special needs, a trust is a very good way to do that. And if you don't want to set up the whole revocable or irrevocable trust, you can do a testamentary trust, which we talked about before. Spendthrift relatives, that's if you have someone who potentially is financially irresponsible or has had some financial challenges or substance abuse or gambling or anything else where giving them the money would not be to their benefit. It shouldn't be held in their hands. It should be kept in a protected place so that they will still continue to benefit from it over the long term. A trust achieves that. Okay. You're actually pretty good at reading. Will you read? Oh, yeah, I'm talking to you. Oh, you are? Okay. Get on the floor.
Susan Johnson, now in her 50s, has done well for herself. She owned a primary home in Virginia, a vacation condo in Florida, and a family cabin in West Virginia, up there in the sticks. She thought her will was enough until her lawyer explained each property would require its own probate process in that state. 3 courts, 3 sets of lawyers, 3 rounds of headaches. Instead, Susan set up a living trust, placed each property into it, and named their children Emma and Jack as the beneficiaries. Now, when Susan eventually passes, her children will avoid expensive, time-consuming, multi-state probate battles.
Great job. Thank you. Okay, you're off the hook for the rest of the night. Thank you so much. Okay, so that's kind of what I was talking about in answer to your question about if you have property in different places. The trust is a nice, elegant solution for that. And so that's one of the things that you can do with it. I had a thought while he was reading, but I was listening. I'll remember it in just a minute. Okay, so we have one more, blended family. Who in the back, closer to the back, will read? You just joined us recently. Do you like to read out loud? Okay, I'm going to ask you.
Setting up a trust. Michael Johnson, Susan's younger brother, was remarried after a divorce. He had 2 kids from his first marriage and 1 child with his new wife, Claire. Michael also had a life insurance policy, a retirement account, and several rental properties. He wanted to take care of Claire if he passed first, but he also wanted to make sure his kids from his first marriage inherited something without everything passing outright to Claire, who could later remarry. His lawyer set up a trust that provides Claire with income for her lifetime, holds the principal for the benefit of all three children, includes asset protection features to minimize estate taxes and keep other creditors away. When Michael passes, his family will avoid the chaos and resentment that often happens in blended families.
Yep. Awesome. Okay, thank you. So I put these examples in here just to sort of illustrate, because I tend to ramble sometimes and go on verbal side quests. I want to make sure we're solidifying the ideas. Does everybody understand the difference between a will and a trust? And we can't answer all the questions right now, but just the basics. Does anyone have a question about that? The difference between them? Okay, any other questions?
So in Brewster's Millions, when Richard Pryor had to spend all that money, just like he had to spend $1 million in 30 days.
Fast.
Yeah. Was that a trust?
That was a trust. Yeah. That was a trust. Yeah. Okay, cool graphic. It's on my website. You can pull it down if you want any review. It's futurecounsellaw.com. This is there on my resources tab. I have a lot of resources there for you. It's like a little library. But basically, for the trust, you are going to, and the funding is the most important part of the trust, by the way. If you choose to set up a trust, after you sign the paper, you still have a couple months of work to do in order for it to be effective. That's kind of like my client who husband passed away and they had the trust, but they didn't put the property into it, remember? So now she's having to go through the multi-state process. So you have to go through funding. Most attorneys that I know for regular people net worth don't take you through the funding process because it is a real pain in the neck. So, but some attorneys do, and there's not a right or a wrong way. Just know in your mind that if you set up the trust, but then you don't go make the trust the beneficiary of the life insurance policy, and you don't redeed your house in the name of the trust, and you don't put the trust as the whatever your bank requires for whatever account you have, then that's not going to be an asset that your trustee has power over to do what you instructed them to do. That asset's going to have to go through the probate process, okay? So just know that. Wills. This might be some of the things that you might want to consider. A will allows you to appoint a guardian for your minor children. And again, you can set up a testamentary trust as well. But it's not safeguarding us against remarriage. It's not allowing us to skip the probate process. It's not shielding children from divorce impacts. It's not assuring you protection in case you become incapacitated. You know, that's something that I care a lot about. It doesn't set up care for children with special needs unless you are setting up a testamentary trust. And it's not keeping your matters private and confidential. Now, that's why trusts are more expensive. Okay, so you do what you can afford when you can do it in the most intelligent way. It takes some thought and consideration to figure out what you're trying to do and how to achieve that. There's always a way to do it. But if you spend however much you have to spend on the trust now, I guarantee you, you are saving tens and sometimes hundreds of thousands of dollars for the people who are inheriting your estate later on. Now, sometimes I have clients who are really wrestling with this. That tend to be my elder clients, that's my favorite people. And they're really wrestling with it. They're like, should I spend this? I'm kind of at the end of my life. I kind of need the money now because I need care. Or I'm moving into Green Spring or wherever. And I say, well, I always will say, you're not going to be here, so they can figure it out. They can. You can just leave it and they'll figure it out. They'll go through probate. There might be some mistakes. There might be some bad blood, but don't stress yourself out too much if you can't set up a trust. Just do the best that you can do. And it's not always the appropriate thing for everybody. Some people do not need one. Yes, ma'am.
What is the average cost of a trust?
It depends where you live. So here in Northern Virginia, I'd say it would be very unusual to get one for less than $3,500. I think the standard's about $5,000. I think if you go to the middle of Kansas, you're probably cutting that in half. Yeah.
Kansas.
Yep. Everyone who attends this class gets $500 off of their trust if they want one, by the way. Okay, if you have these things that I mentioned before, you want charities to benefit from your estate plan. You have someone with special needs or spendthrift considerations. You have retirement accounts. They have to be treated entirely different than any other asset. Or you think you're going to be qualifying for government benefits later, then you're going to really want to consider whether a trust can benefit you. Before I move on to these documents, does anyone have any more questions about trust they want to ask or wills? Yes.
When you say government benefits, what do you mean by that? Like VA benefits or like?
Yeah, it can be something as simple as student loans. It could also be Medicaid or Medicare, because when you're filling out those qualification documents, they look at any asset that can be attributed to you that the IRS would say, this is this person's asset. You can take assets and you can put them in a special trust. Okay, we call it a MAPT, Medicaid Asset Protection Trust, or an IRA retirement trust or something like that. And then that keeps it so that you actually never have control of those assets again, but they can be spent for your benefit. The government will do a look back on that. So if you put $500,000 into one of those trusts and now the next year you're trying to apply for those benefits, they say, no, we're treating this as if it was your assets. It's about you have to get 5 years out before you have to qualify. So you do have to plan in advance for that. Okay, who here has a power of attorney? I think I asked that before, but I forgot the answer. Okay, has anyone ever needed a power of attorney? Yes, ma'am.
I was in the military.
You were in the military. I was a military spouse for 13 years. What branch?
Army.
Okay, we were Navy. It's pretty normal for service members when they're going on deployment or they're being stationed elsewhere to execute powers of attorney so someone can help manage their affairs. Was there any other instance in which you needed it?
No, that was just.
Okay. And so did the person who you appointed as your power of attorney have to use it?
I think they did.
Like pay a bill, call the cable company, do a real estate closing for you, any of those things, you'll need a power of attorney. Does anyone know what the difference is between a general durable power of attorney and a springing power of attorney? And guesses are totally accepted.
One does clerical errors, one does legal errors.
Love it. Thank you for the answer. Not accurate, but I appreciate the effort. One is temporary and one is not. That's a good way to answer that question, actually. What do you mean by that?
There's some power of attorneys that can be for a specific time period, let's say for a year, and there's others that are just until the person passes away.
Yeah, that's correct. And if you have it specifically that it is a springing power of attorney, in addition to what you just said, which is good information, then it will only come into effectiveness upon a condition happening, which is usually when we're incapacitated. But it could also be if I'm overseas for more than 30 days, right? And so every power of attorney is going to specify how long it's effective. Usually they will expire. If you want to have a specific general durable power of attorney, you say in perpetuity, this is never going to expire, even if I become incapacitated. But if you don't want your sister to be able to immediately be doing things in your name, you're going to have a springing power of attorney that says she can start using this paper if XYZ happens, okay? That's a power of attorney. Now, why would you want to talk to your parents or your loved ones about a power of attorney now? To being in the event that they become incapacitated, how hard do you think it's going to be to call the Social Security Administration or go down to the DMV and retitle the car, et cetera? Okay. Was my mom able to sign her name? Yes. Was it a legal signature where she had capacity? No, it was not. And if you're dealing with healthcare individuals or other individuals who already know she has Alzheimer's, they're not going to take that signature. Okay. Then we've got and usually the power of attorney is helping us manage our personal and financial affairs. It's not medical stuff. Okay. Does anyone here work in the healthcare industry or have any adjacent contact with the healthcare industry? Yes, sir. Could you tell us?
Firefighter EMT.
Great. Okay. And yes, ma'am? Work with the Nova Healthcare, firefighter, EMT. Yes, ma'am. Registered nurse. Okay, great. So I'm going to go to our nurse and ask you a question. Oh, good. Thank you, Derrick. At what point do we call upon a healthcare agent to step in and make decisions for someone? Healthcare decisions.
If they're incapable or unable to answer for themselves.
Correct. If you're incapable of making your own medical decision. So I'm going to ask you a couple more questions just to illustrate it. If someone can communicate by blinking, are they capable of making their own healthcare decision according to your training?
I guess it depends on, I would say yes, like we'd say blink if you can hear me or blink if you understand me. So yeah.
What about if they can only communicate by writing?
Yes.
I would agree with you. I say, as long as we have breath in our bodies and our brains can understand and we can express our wishes, whether it's nodding, blinking, spitting, writing, whatever that is your decision. You have agency over your medical decisions. When the doctors determine, and this goes back to that intersection of legal and medical capacity I was talking about earlier, when the doctors determine, or healthcare professionals, such as a nurse, that you don't have capacity to understand and make a fully informed decision and then be able to communicate that, that's when they're looking at calling somebody in. And that's usually your agent or your next of kin. Am I correct about that? Right. So if you haven't designated who your agent's going to be, what happens? If there's no agent designated in an advanced medical directive that's on file, who are they calling to ask what to do about you? It's your next of kin, and they might not always know who that is. It might be really hard for them to figure that out, and the clock may be ticking on the medical decision that they have to make. So in that instance, usually the doctors will make it for you. Yes, ma'am.
Can you explain the difference between the power of attorney and guardian when it comes to medical?
The question on the table is, what is the difference between the power of attorney, someone I call the agent, and the guardian? Okay. Are you talking about someone who manages your affairs for you and makes your decisions for you? Oh, hold on.
Within the past year, we had a situation with my ex-mother-in-law, which has dementia. Her husband at the time was having issues with getting paperwork done versus power of attorney paperwork versus guardianship. He originally got the wrong paperwork, trying to get everything situated. Unfortunately, the stress, he passed away as well, which added more problems.
I don't think it.
Okay.
Or maybe
So just trying to have understanding.
Okay.
Thank you for coming.
This is a really good question. It comes out pretty frequently when we're talking about these later in life situations. So thank you for posing that. But let me start with an illustrative example. You need to go to your mother who has early onset Alzheimer's so that you can accomplish something for her, okay? I bring her a power of attorney to sign, but she doesn't know the paper that I am putting in front of her. The bank or whomever would accept a signed power of attorney, but it's really not legal for her to sign something if she doesn't understand what's in it. So if you are at that point where she's not able, or the person is not able to execute that power of attorney and fully understand it, then you have to go to court and get either a guardian or a conservator. They're slightly different, but they're basically the same thing. One is who's in charge of you, and the other one is who's in charge of your financial accounts, okay? And you have to say to the court, this person doesn't have capacity, and we need someone appointed who's going to manage their affairs. You can either volunteer for that or not volunteer for that. You're just making the court aware of that. And then the court will appoint some doctors who regularly do this to evaluate whether someone has capacity or not. Because we're not just taking away people's rights, right? The medical doctor has to be involved. That actually is one of the most stressful things that could happen to a family when their family member's not able to sign the power of attorney, because you have to go hire a lawyer, you have to file the stuff, and then whatever you are trying to accomplish cannot be accomplished. If you were trying to buy or sell a house or have them sign paperwork so they can move into their assisted living, but you have to pay for that with the proceeds of the house you're going to sell for them, and now you can't accomplish any of those things until you get this person appointed. And as we all know, the wheels of justice turn slowly. Okay, so that was a really, really good question. Both of those people that we're talking about are different than your healthcare agent who's in your advanced medical directive. So under your agency, under the advanced medical directive, that's when someone can't make a fully informed decision. And so you're saying, okay, well, I think what's in their best interest is that we get this treatment, or we get this second opinion, or we deny this treatment, or et cetera. That's what the healthcare agent power of attorney does. And then if you fast forward to other situations, it's, are they in a coma? Are they in a vegetative state? Do they have a terminal illness and they're in the end stages? How are we going to handle this? Your next of kin or your agent will in general do what's in your best interest according to the best of their ability. But in the advanced medical directive, you're telling them, you're giving them guidance. You're saying, if A, then B, if B, then C, if C, then D, or do it the best that you can do it. They're always going to have that ultimate power, but it's really a guidance document for them, and it makes the healthcare professionals defer to what they are saying. Any questions about that? The most different than everything else that I've said tonight in this presentation, it does not matter how primitive or where you get your form for the advanced medical directive. I think mine are the best for reasons that I'll tell you, but it really doesn't matter. Having a partially effective one is just as good as having a great one if the moment comes when it's needed, right? So I would say don't waste time getting that. The reason that I like mine is because it helps people. I have like a very robust intake questionnaire that makes people think through all these different situations. And then if someone's having to step in to make decisions for you, they're not having to just tear their hair out and be like, what would she want under these circumstances? It's like really specific about a bunch of different options. If you're the type of person that doesn't want to be that specific, and I do have clients like that, they say, I don't care, they should just decide it. And I say, okay, we can do that too. Did you have a question?
Yeah, can multiple people be a power of attorney? So like say my brother and I, can we be the power of attorney for our mother?
Yes.
Okay.
Yeah. That comes with its own inefficiencies, as you can imagine, but sometimes it's appropriate. So you can. Yeah, absolutely. Or you could have one and then you can have an alternate if that person's not available. What you want to think about when you're appointing co-fiduciaries in any sense is if they both have to be there and they both have to agree, is that potentially going to delay progress on anything that has to be done? Okay. And then the HIPAA authorization is, do I need to get mom's medical records because she's in this facility and I need to take a look at it because I might want to move her somewhere else or get a second opinion or make sure that she's getting the care that she needs. And they won't give it to me because she still has the ability to make a fully informed medical decision. But maybe she's tired or maybe she's sick and maybe she would benefit from one of her children or a loved one being able to look over her medical records. If you don't have this HIPAA authorization, you're not going to get it. So that's why I like to have that. Any questions about that? Okay. Okay. Would you mind reading this? You front row people, but you were talking about it at the beginning, how you like to sit in the front row.
I do. Susan Johnson, now in her late 70s, started showing signs of memory loss. Her bills piled up, and she forgot to pay her property taxes, risking penalties. Her son, Jack, needed legal authority to step in and manage her finances. Because Susan had signed a durable power of attorney years earlier, Jack could immediately step in to pay bills, manage investments, and even sell her unused condo to free up cash for her care. Without it, Jack would have had to go to court for guardianship, a costly and time-consuming process.
I really like that illustration. Anyone else over there want to read the next example? Because you know I got two. Okay. Derrick?
Yes. Grandpa Johnson had always been clear that he didn't want to be kept alive on machines, that there was no hope of recovery. One night, he suffered a massive stroke and was left unable to speak or make decisions. The hospitals need to know whether to put him on life support. Fortunately, years earlier, he had signed an advanced medical directive appointing his daughter, Susan, as his healthcare agent. She presented the documents to the doctors who followed his written wishes. Because of that, his family avoided painful fights at the bedside about what Dad would have wanted.
If you have an advanced medical directive and your family doesn't know where to find it, or you haven't filed it with your healthcare provider or the hospital system, then they can't use it. So please, if you do draft and execute one of these, the best rule of thumb is to go ahead and file it with your healthcare provider, either your primary physician or Inova, Centera, Virginia, whichever one is your hospital group, so they have it just in case. But also tell your family where it is. Okay, we're basically getting close to the end, and there are snacks and food, so it's coming. We'll wake you up in just a second. Common misconceptions about whether or not you need an estate plan is that I'm too young. That's absolutely not true. My youngest client that I've ever had is 21. She did not care as much about the will. It was the power of attorney and the advanced medical directive because she's going to the Peace Corps and she wants her mom to be, all looped in on how to help her with her affairs if it becomes needed. I don't have much. That's true. So you might not need a trust, but having a will can really help your family and these other estate planning documents we've been talking about. My family will figure it out. I love this one. Yes, just let them figure it out. Absolutely. It might be hard. It might be expensive for them, but it's not your problem anymore if you're not here, okay? But if you do care, you probably want to put something in place. Here is how I do my planning process, and I recommend that you approach it the same way if you decide to do the plan. First, you need to figure out, as I've been saying, what are the outcomes that you are trying to achieve. Then you're going to find out how you want to structure things. So this depends. Do you have special needs? Do you have assets in diverse jurisdictions? All these things I've been repeating myself on. Then you're going to need to figure out which documents need to be drafted, and you find someone to draft them. An attorney or another professional who's experienced in these things, sometimes a financial advisor, can help you guide you through this thought process. When it comes time to draft the documents, financial advisors should not be drafting your estate planning documents. So use either online, right? But be careful about that, or just go with an attorney. And there's different workshops that there are for people who need, don't have the means to pay for it. So there's options. After they're drafted, make sure that you read them, every word on every page, please. Okay. And then you're going to sign it according to the formalities of the Commonwealth of Virginia. And then, of course, you're going to sleep better at night because it's great. If you had a trust, you got to fund it, but you have to put everything where someone can find it. I think that this probably could be its own presentation, which is choosing the right fiduciary trustee. How do you decide who's going to be the trustee, the successor trustee, the co-trustee, the healthcare agent power of attorney, the durable power of attorney, the executor of your will, the advisor? These are not easy jobs. Many of these positions are compensable positions. And when I say that, it means that the person who is doing them is entitled to compensation from your estate. Because it's not easy. It can take several hours, a month or a week to do it, depending on the complexity of your estate. So you need to find the right person who isn't going to say, gosh, I can't believe that grandma put me in this position. Doesn't she know I just had a baby and I have a new career and I just can't do this? You also want to put in there for your fiduciaries enough support so they have the expert help and the ability to get the expert help that they need. So choosing the right fiduciary is hard. It's not just who helps me with most of my stuff right now. It's who's going to be ready to deal with my family after I'm gone and survive all of those ins and outs. So what happens to everything that you own? If you have personal items in Virginia, you can put them in the will, or you can make a writing up until the last moment that you're alive that says, Opal's going to get my coin collection. As long as people can find that writing and they can prove that you did it, doesn't have to be notarized. You can just put it on a piece of paper in your handwriting somewhere on a desk. You do want to make sure people can find it. Then the court will make them honor that, okay? Even if it says something different than what's in your will, you can change it. You can say, hey, just kidding. Even though I said that you have to do it by formalities, that doesn't apply to your personal property. You can always decide at the last minute to give your motorcycle, to Sammy. If it's your house, if it's in a trust, it just immediately becomes the trustee's property to do with as you instructed. If it's not, it has to go through probate with a bunch of exceptions for Virginia. If your only heirs that you left behind were your children, it's automatically your children's property, okay? So you don't have to go through probate for that. And they would just file something called a real estate affidavit. Your money and your accounts are going to pass to who you said they go to. Or if you died without a will, it's going to go according to the law of Virginia, lineal descendants, parents, and then out the branches. And you can obviously revise instructions or amend your will or just restate the entire thing anytime in your lifetime. You're not bound to anything that you said before. Best practice is to actually destroy the prior copies rip them up, burn them, flush them, put them in the dumpster. Virginia does require the admittance of an original will. Okay, so they have to have the original document in order to probate it. If all we have is a copy, extra hearings that we have to go through to authenticate that copy. So if you have your original will and you're doing a new will, rip the old one up. Taxes, there's, I don't know what to say. Oh, and final wishes. Talking about where you want to be buried, whether you want to be cremated, what kind of service you want. These are important things to write down for people. Making sure that everyone knows where your documents are. I'm going to do a quick plug for downsizing before you get to the end of your life. Looks like most of us here are more at the beginning or middle of our lives. But gosh, I am just in fear of when my father passes away. He has accumulated so much stuff in this big, huge house that he has. And I'm just like, please get rid of it because I don't want to spend 6 months going through this. So downsizing is great if you can do it, and start the conversation now. I think that's it. There you go. Contact me anytime. Anybody have any questions? Yes, ma'am.
On your bank accounts and things like that. I've actually worked in banking and I have seen paid upon death notices on those accounts. Does that kind of, I guess, supersede the will in a sense?
Yeah, it does. So if you have an account and you designate who the payable on death beneficiary is going to be, and I have a client who's doing this right now, her grandmother's will left all of her assets, and that included this one account that had a lot of money in it, to be divided between her 3 grandchildren. But she made the granddaughter, my client, her payable on death beneficiary. Okay. So there's a conflict there. Is it all her money because she's the beneficiary of the account, or is it to be held and divided between all 3 people? Well, that's her money. She can take it. They can come up with a challenge and take her to court and say you weren't supposed to do that. But by law, the default is the bank is just paying it out to granddaughter. Yeah. But that's part of the funding process, and what you want to do, you want to make sure that all of those things are not in conflict with one another. Any other questions? Okay. I brought not very many brochures because I was surprised that there was such a great turnout, but I have a couple with me and they're down there, and my business cards are down there as well. And I'm happy to answer any questions anybody has at any time. Thank you, Derrick, for the opportunity.
Give her a round of applause, everybody. Wow. Did you guys get a lot of value out of this tonight?
Yes.
Thank y'all for tuning in online. This has been a great day, great one. Make sure we got your email address. You sign up for the next session. We're really, the goal at the end of this, for how many people, only one person had a will. Yeah, so by the time we get to week 8, the goal is for you to have created at least one will. How many can commit to getting one will done in the next 8 weeks, right? The will is the easiest part of it, right? And then we could talk about trust, and we'll go through insurance. So the goal by the end of this 8 weeks, for this to have been successful use of your time, is to actually at least get a will done, and we all commit. And if you already got a will, when we get to the insurance part, to either get insurance or to upgrade your insurance. So those are some performance metrics we have for this this series. It's not just for you to sit here and get information. I used to watch G.I. Joe. At the end, they used to say, knowing is half the battle. The other half of the battle is you got to apply what you know. The true power comes in the application of the knowledge. It's not what you know that makes you who you are. It's what you do with what you know. And so the goal here is to apply this information. Phoenix, thank you for giving us a great first introduction. Future councils, give them a round of applause. Make sure you connect with them and you stay connected. We're going to hang around for the next 20, 30 minutes. We got some sandwiches and stuff because we had y'all out here for dinner time. So you ain't even got to think about what you're going to get. Let's just go into the back room and we're going to sign off. Yeah.
One quick question. So
yes.
Next Wednesday
Next Wednesday at 6:30. Yeah, that's going to be via Zoom. So make sure you sign up. There's a sign up link, and then you'll get emails. It will make sure by Monday you get another email reminder link coming out showing it is. So make sure that at the front they have your information, and we'll be sending out weekly messages to let you know about this so that you do not miss a session. All right. Thank y'all for coming out. God